Delays to the Opal Tower court case. Let's have a look. Hello everyone, Florian Heise here and welcome to another episode of Heise Says. I thought this afternoon we would have a look at an update to the Opal Tower court case, the class action lawsuit that the owners and residents of the tower are taking against the New South Wales government for the peculiar situation where they're owners of the land and hence become part of the development. So, Sydney Opal Tower class action lawsuit, 42-day delay. Doesn't make sense, the judge says. So it's a 42-day delay. Let's learn more. A judge has blasted a rule giving the New South Wales government another month, more than a month, before it needs to respond to a multi-million-dollar class action over Sydney's notorious Opal Tower. Supreme Court Judge David Hammerschlag vowed to deal with the case expeditiously and said it doesn't make sense to have a month-long hiatus before the proceedings gather pace. I guess it could be frustrating for the owners and residents living in Opal. The ABC exclusively revealed last month that owners of Opal Tower units are seeking millions of dollars in compensation from the Sydney Olympic Park Authority, SOPA, after they were forced to flee the building on Christmas Eve when cracks appeared in the foundations. SOPA is a New South Wales government-controlled entity which owns the land on which the tower was built. The case was heard for the first time during a Supreme Court directions hearing, where the parties discussed a practice note from the Chief Justice which dictates the next step in legal proceedings must take place 42 days after the filing of the proceedings. Why would that be? Lawyers viewing it, could you please let me know in the comments, to provide time to allow the parties to prepare? I'd assume, I would assume. The rule cites the unique complexities presented by class actions compared to other forms of litigation. The barrister for the residents, Nicholas Owens, SC, told the court the case had not come as a surprise and any delay was unsatisfactory. Your Honour knows that there has been independent experts engaged by the state, he said. This will be interesting. The outcome of this case will be very interesting to see what happens. They've looked at the building, they've worked out what's gone wrong. This hasn't come out of the blue. Well, perhaps it hasn't come out of the blue, but the fact that the government-controlled entity owns the land maybe adds some complexity to it. Perhaps. The case will come on quickly. Justice Hammerschlag described the situation as swings and roundabouts and set another directions hearing for September. I propose to make comprehensive directions to ensure the proceedings are resolved expeditiously in September, he said. I'll give you assurance this case will come on quickly. But our legal system in many ways is necessarily slow. It's necessary to allow for time to do these things properly, hopefully. Because we've seen this outcome of industries where it hasn't been slow, where it's been overheated, where it's been going faster, haven't we? Haven't we? Maybe Opal is the outcome of that. Justice Hammerschlag said he intended to write to the Chief Justice about the practice note. It doesn't make sense at the moment to have 42 days hiatus period, he said. It's a historical work which I think had its origins elsewhere. Okay. Well, he'd be the best person to make a decision on that, but those changes I can't imagine will affect this case. It would affect other ones in the future. The lawsuit claims a breach of the Home Building Act. It claims the $170 million complex was not constructed with due care and skill, that the tower was not built in accordance with the plans and specifications, and was not reasonably fit for occupation. Hundreds of owners have been in temporary accommodation for more than 7 months. 7 months, guys. 7 months. They claim losses due to a drop in the valuation of their apartments, along with a loss from rental value. Some residents had finally returned to their homes last week, only to find the water wasn't working. Well, that hopefully that can be sorted with a quick phone call. It can't be, that drastic a situation. You can see here we've got the damage, and it's an example of the cracking happening at Opal Tower. So it looks like this case has been delayed by 42 days, and we will see what happens. Here's the key points. The owners lodged a multi-million-dollar compensation claim against the state government in July. The lawsuit claims the $170 million complex was not constructed with due care and skill, and Opal Tower was evacuated on Christmas Eve after residents heard a loud cracking noise. What we will do, I'll have a look at the Home Building Act. One moment. So let's have a look at some portions of the Home Building Act, and to get a better understanding. And here, I looked up the terms. This is from 18B, warranties as to residential building work. Now, Clause 1, the following warranties by the holder of a contractor license or a person required to hold a contractor license before entering into a contract are implied in every contract to do residential building work. A warranty that the work will be done with due care and skill and in accordance with the plans and specifications set out in the contract. So there you are. That's an interesting thing. When you're doing design and construct, and the documents that you do, when you prepare them as an architect, they are all part of the contract. They're all part of the contract, regardless of design and construct. But with design and construct, they can kind of change. So you need to get people to sign every page, stamp and sign every page, every contract, every page of the specification, because they're legally part of the contract, and you want a signed, stamped, dated version of that document, because that's what you always go back to. B, a warranty that all materials supplied by the holder or person will be good and suitable for the purpose for which they are used, and that unless otherwise stated in the contract, those materials will be new. Isn't that interesting with regards to the fire cladding issues in New South Wales? Would you think a material that is an alternative to probably what was specified, hopefully, that doesn't meet the National Construction Code requirements for flammability, do you think it would meet this clause? 18B. A warranty that the work will be done in accordance with and will comply with this and any other law. So, by agreeing to it and by applying with these, by placing a contract in place, the builder is agreeing to this. This is what the builder is signing up for when you get a construction contract in place. You can't, here's the thing, you can't sign away the responsibilities you have under this act. The builder can't go, I tell you what, if you sign this special contract here, we'll just cross out this requirement here on the clause. So I can substitute that one. I'll give you $5,000 off. How about that? You happy? They can't do that. That won't hold up in court, or it shouldn't hold up in court. It's to do with the hierarchy, the legal hierarchy of documents of legislation. And we'll do a video on that a bit later. I'll try and get Rachel to do it because she's good at it. So D, a warranty that the work will be done with due diligence and within the time stipulated in the contract, or if no time is stipulated, within a reasonable time. So, this stuff isn't that difficult to understand, and it makes a lot of sense. So everyone getting a home done should be familiar with this. E, and even this will overrule other contracts that you can't contract out of this. It's not possible. E, a warranty that if the work consists of the construction of a dwelling, the making of alterations or additions to a dwelling, or the repairing, renovation, decorating, or protective treatment of a dwelling, the work will result to the extent of the work conducted in a dwelling that is reasonably fit for occupation as a dwelling. So that's saying that the building has to still be fit for occupation. Has to be fit for occupation. So if you're coming home, so the people coming home here, back to Opal, and finding their water isn't turned on, that's not fit for occupation. Not for long term. Sure, it can be short-term for a couple of hours, perhaps, if you're given notice, but it's not fit for occupation, is it? So, F. A warranty that the work and any material used in doing the work will be reasonably fit for the specified purpose or result. If the person for whom the work is done expressly makes known to the holder of the contractor license or person required to hold a contractor license or another person with express or apparent authority to enter into or vary contractual arrangements on behalf of the holder or person, the particular purpose for which the work is required, or the result that the owner desires the work to achieve, so as to show that the owner relies on the holder's or person's skill and judgment. So pretty much, that's kind of a catching clause. You know, as the person you're depending on this other professional person's capacity. You're depending on the professional skill of the builder to act on your behalf, on your interest, and ensure this is complied with. You have to communicate with them what the purpose of it is. You can't change your mind and not tell them and then nab them for this. That's where I think it'd be an issue. And point 2 is that the statutory warranty implied by this section are not limited to a contract to do residential building work for an owner of land, and are also implied in a contract under which a person, the principal contractor, who has contracted to do residential building work contract with another person, a subcontractor to the principal contractor, for the subcontractor to do the work or any part of the work for the principal contractor. Okay, so the subbies are responsible for it too. You know, it shifts. The responsibility goes to everyone. So guys, I thought it would be worth having a look at that, considering these are some of the claims that they're made. Do you think it, you know, what do you think? Let me know in the comments. Do you think a duty of care was done by the builder with regards to Opal Tower? With regards to the subby? Looks like clause 2 has gotten there. If the subby didn't put the incorrect Rio in there, or the incorrect strength of concrete, or some of the other issues that have been noticed on this building, I wonder. It'll be interesting to follow this case. Anyway guys, like, share and subscribe. Ding the bell to see my daily content, and I'll see you later. Take care.